Thanks so much for being here and thanks for organizing this webinar. I'm Liz Morris. My pronouns are she, her, and I am the co-director of WorkLife Law, which is a research and advocacy organization that advances gender and racial equity by strengthening legal rights for pregnant people and for family caregiving. And we seek to ensure that people are able to take care of their health, especially related to reproductive health, to take care of their family members without compromising their economic security, whether that's being able to keep their jobs or being able to stay in school. So both in employment and in education. And today we're going to be focusing on employment protections, of course, for pregnant people and for family caregivers. And um, I've included a lot of content in this webinar because my goal in speaking to all of you is somewhat to sort of provide a crash course in all of the legal protections that exist in this space so that you'll be in a position to, even if this is not your primary focus area as a legal aid lawyer, I know you all do literally everything under the sun. Even if this isn't your primary focus area, you'll feel equipped to flag legal issues when they're arising for your clients, and you'll know where to go or where to send your clients for additional in-depth support. And I'll just let you know that WorkLife Law offers a free legal helpline. We speak to almost 600 people every year related to issues on caregiving, pregnancy in the workplace and in education. And so we are here as a resource. Following this crash course, we're here as a resource to you all and to your clients to provide support. Let's see, how do I get to the next slide? Okay, there we are. So I want to start by just flagging two scenarios, and these are hypothetical people, but these scenarios are based on things that we see every day on our free legal helpline. I'm going to present one on family caregiving, and then I'll present one on pregnancy. And excuse me, I'm having a little bit of technological. Okay, got it. And my goal is to keep having this thing pop up. Okay. And my goal here is to present the types of situations that arise so that when we're going through the law, you'll sort of have in your mind the types of issues that can be addressed with the laws that we're going to be discussing today. So I'll present these two hypotheticals, and then I won't sort of share how they should be resolved. At the end, we'll revisit them and sort of apply the legal protections that we'll be discussing to these factual scenarios. Okay, so Grace works at a call center. Her father, who has dementia, recently got lost after wandering outside when Grace's mother was in the shower. Grace lets her coworkers know that her parents are moving in. That'll allow Grace to support her 72-year-old mother, as caring for her dad is an intense around-the-clock job. Grace uses up her state-mandated sick days when her mom gets the flu. The following month, Grace is late on two occasions, in both instances because her father was experiencing a dementia-related health issue. Dad has a medical appointment coming up when big decisions will have to be made, and Grace asks to take off work early on that day to attend the appointment. Her boss responds that Grace can't have any more time off and is going to have to decide whether she wants to take care of her parents or keep her job. This is the type of thing we see come up all the time. Here's a scenario in the pregnancy context. Rosa comes to you for assistance securing Medi-Cal benefits when she's 12 weeks pregnant. She mentions that it's been a very difficult pregnancy between morning sickness and exhaustion, and she has to wake up every morning at 3 a.m. for her job picking strawberries in the field. You asked some follow-up questions about working while pregnant, and which great job asking that follow-up question. Somebody who's really struggling with their health, who works, how are your health issues during pregnancy impacting your work? Great to sort of probe into that. And Rosa mentions that she's very worried about the impact on her pregnancy of the pesticides that are sprayed on the crops, as they have made her lightheaded, and there are also rumors that they're dangerous. When you empathize with Rosa, she responds that she has no option but to keep working this job so that she can pay her bills. So we'll revisit these at the end and discuss how the legal protections that we're going to learn more about apply. All right, so here's our agenda. First, I want to share workplace protections related to pregnancy, reproductive health, and caregiving in three areas. We'll start with anti-discrimination and anti-retaliation protections, and then we'll move to time off or paid leave and wrap up with reasonable accommodations. After that, I will share some of the resources from WorkLife Law, including our free legal helpline that you and your clients are welcome to call, and our attorney network. Okay, so let's jump into the substance of the law, starting with anti-discrimination and anti-retaliation. I'm going to first discuss caregiver-related discrimination, retaliation, and then pregnancy-related discrimination, retaliation. Okay, so first of all, what is caregiver discrimination? That's an important starting question. It's negative employment actions that are taken because someone is a caregiver. So termination, reduced pay, changed schedule, harassment, normal sort of forms of adverse employment actions that come up in the employment context in the workplace. So those negative employment actions taken because of pregnancy, childbirth, or breastfeeding, or caring for children, aging family members, or family members who have a disability. So in the real world, what does this kind of discrimination actually look like? For example, a pregnant worker gets taken off of the work schedule because her boss thinks that she won't care about her job after having her baby. So notice here, the person hasn't even had the baby. They're pregnant, and the boss is already sort of making assumptions about her commitment to her job. In this area of the law, assumptions about how caregivers will behave and their commitment to their job, assumptions that are not based in job performance or reality are often the basis for this form of discrimination. Here's another example. A new dad gets fired when he comes back to work after taking time off with his baby, and his boss explains that men shouldn't stay home with their kids. And so this is, again, based on assumptions about how caregivers, in this case, should behave. If you're a man, you shouldn't perform caregiving responsibilities. The assumption being your wife should be doing that. The hiring manager ghosts a job applicant after he mentions that his partner has a disability. They fear the company will have to pay more for insurance. As soon as a worker reveals her husband has cancer, her boss starts tracking every minute of her time and exaggerating issues to justify firing her. A parent with postpartum depression is told by HR that they can't take time off to seek help, even though their coworker took leave after a heart attack. So caregivers sort of being held to higher standards and scrutiny, where other employees are given freedoms and permissions that the caregivers are not receiving. A boss won't give their best worker a promotion just because she is a mom. The boss says it's because moms won't be willing to travel for work. Again, assumptions. A worker's mom moves in with him soon after he gets fired because his boss believes that the worker might need to take days off to help his mom. So these are all examples of how this pops up in the real world and on the helpline. Next important question, is caregiver discrimination illegal? The answer is that there's a patchwork of legal protections. There is no California or national law protecting workers from discrimination and harassment because they care for a family member. So there's no explicit protected category, of caregivers or family responsibilities. There was a law passed in California, and it was vetoed several years ago. It was vetoed by Governor Newsom. However, there are various federal, state, and local laws that can help. Of course, like in all employment, with all employment laws, it depends on the employee's situation as well as the size of the employer, what's going to actually apply and help the particular worker. Sometimes more than one law is going to provide protection, but sometimes no law will provide protection. So, what I'm going to do now is sort of go through a few principles where where again, there's not an explicit category that caregivers or people with family responsibilities are protected from discrimination, but we have certain principles that we can apply as part of this patchwork to get people legal rights. And the first principle is that anti-discrimination protections are strong for birth parents around the time of birth. And that's because California's Fair Employment and Housing Act, referred to as FEHA, prohibits discrimination by employers that have 5 or more employees on the basis of pregnancy. And the same thing is true of the Federal Pregnancy Discrimination Act, which applies to employers that have 15 or more employees. So pregnancy and childbirth, there is a lot of protection there for the birth parents, but the longer the more time that passes, the weaker that protection becomes. More time that passes from the time of childbirth. Another important principle is that anti-retaliation protections are strong for employees who take job-protected caregiving leave, but mostly around the time that they request, take, and return from the leave. So if somebody has a right to take leave, then their job, then they're protected from discrimination and retaliation for taking that leave or for requesting it. So that's under the California Family Rights Act and the federal FMLA, which both prohibit retaliation for requesting or using protected leave. And here, temporal proximity is the strongest circumstantial evidence of retaliation, which is basically to say the closer in time the negative employment action is to the time when the person requested or took the leave, the stronger the evidence of discrimination. So if somebody is fired 2 days after they get back from leave, that's very strong evidence of illegal retaliation. 2 years later, not so much. Another legal principle that we rely on to address discrimination against caregivers is discrimination based on an association with someone who has a disability, which is illegal. So under FEHA and the Federal Americans with Disabilities Act, or the ADA, employers are prohibited from discriminating against an employee based on the employee's association with somebody who has a disability. And associated with is very broad, and it includes caregiving, which means that this form of protection covers all family and chosen relationships. So it's not just discrimination against somebody who has a family member with a disability, it's any form of association, caregiving, regardless of what kind of relationship is at issue. However, the catch is that the employer must know or believe that the care recipient has a disability. So if the employer discriminates against, in our hypothetical, I'm forgetting which name I used, but the worker whose parents are moving in with them without knowing that the father has dementia, then that wouldn't capture association with somebody who has a disability. But if the employer is aware that the person has dementia, that the care recipient has dementia, and then discriminates against the employee, this is the legal theory that we use to get them rights. And disability is broadly defined. Examples include dementia, Alzheimer's, cancer, arthritis, heart disease, diabetes, vision and hearing loss, depression, and anxiety. The last legal theory that we use to capture discrimination against caregivers is discrimination based on sex stereotypes, and which of course is illegal. So under FEHA and Title VII of the Civil Rights Act, the federal civil rights law and employment, it's illegal for employers to discriminate based on gender-based stereotypes that say how a person of a particular sex should behave, or stereotypes that predict how that person will behave. So we saw those scenarios earlier taken from our helpline where employers are making assumptions about, and in addition to like our helpline, there's also vast social science research showing that people make these gender-based assumptions about caregivers. You know, you're a mother, so you will do this or you should do this. You're a female caregiver, so you will do this or you should do this. Same thing for men, that they shouldn't be engaged in caregiving. And so, of course, making employment decisions based on what the employer or the manager thinks somebody of a particular sex should be doing, how they should be behaving, or how they will behave is illegal. So examples, demoting a male caregiver based on the assumption that he shouldn't be using his PTO to care for a sick family member because he's a man. Quote, shouldn't your wife be doing that? Another example, refusing to promote the most qualified employee because of gender-based bias that says she will not be committed enough to her job as a mother caring for young twin children, and promoting a father of four children instead, probably based on the assumption that he needs the money more. So you can see that that's sort of based on gender, sort of stereotypical gender and family dynamic norms. Okay, so that's what I have to say about discrimination. No robust, clear right for some of the groups of caregivers that we're talking about today, but there are creative ways to get at the problem. Let's shift gears now and talk about time off and paid leave. I want to just provide a quick note on paid sick days because it is a legal right that people have in California, and then we'll spend the rest of the time talking about extended periods of leave. So paid sick days are a good option for very brief periods of time off, or a good option for people who aren't eligible for longer periods of caregiving leave. All California employees are entitled to 40 hours or 5 days of paid sick leave annually. So it's quite a short period of time that people can access for time off here. Important to keep in mind the anti-retaliation protections. So if somebody does use this leave and they face negative employment actions as a result, then that could be your sort of hook here. All right. Want to talk now about paid leave and job protection, though, so extended leaves. Before we do that, I think it's really important to distinguish what we mean when we say paid leave versus what we mean when we say job protection. These are two separate rights provided by different statutes that have different, employee or employer size thresholds and eligibility criteria, and they're just totally different protections. Obviously, they're very important working together, but want to think about them separately. So paid leave provides partial pay while the employee is working less or not working for one of the protected reasons. And job protection protects the employee's job, giving them the right to return to the same or a comparable position. So paid leave refers to income replacement, whereas job protection refers to your job will be here when you're done with your leave. You will have a job to come back to. Paid leave in California, we have two forms, the paid family leave program and also the state disability insurance program. And we're going to talk about both of those today. I know that many of you support your clients in accessing these income replacement benefits. Job protection is provided under a number of laws for caregivers and pregnant people. The California Family Rights Act, or CIFRA, the Pregnancy Disability Leave protections in California, the Pregnant Workers Fairness Act, which is a new federal law that we'll talk about today, and the Fair Employment and Housing Act, FEHA, which provides accommodations and leave for people who have a disability. For paid leave, employees apply with the California Employment Development Department, or EDD, whereas with job protection, people request the time off from their employer. So you can see how these two categories of protection work together, but we need to be thinking about them separately in terms of who qualifies, why, how they access it, etc. All right, so I want to start off by talking about job protection during pregnancy and childbirth. So during pregnancy and childbirth, you need time off, and you want to ensure that your job will be waiting for you when you're done. So important law to know about is the pregnancy disability leave provision in the California Government Code at 12945. It applies to employers with 5 or more employees and requires that they provide time off for the employee's health or the health of their pregnancy. And I should say time off for the health of their pregnancy, childbirth, or a related condition. And this law provides up to 4 months of job protected leave with continued health insurance benefits for the health of the pregnant person or their pregnancy or related to childbirth and related conditions. So up to 4 months off, it's a very strong protection. As far as I know, that's the strongest in the country. And it's regardless of hardship. So there's no undue hardship exemption here. 5 or more employees, you must provide this 4 months of job protected leave when a healthcare provider certifies that it's needed. And health insurance benefits have to be continued during that entire period. Under this law, employees must be returned to the same or a substantially similar job at the conclusion of the leave, and it can be taken intermittently depending on what the medical needs are. It doesn't have to be taken in a single chunk of time. Beyond the 4 months, additional time is available absent undue hardship. In other words, the employer can argue that there's an undue hardship in providing additional time under 2 laws, the Pregnant Workers Fairness Act, the new federal law that I mentioned earlier, and FEHA's disability accommodation provision at California Government Code 12940M, which applies only if the person has a disability. So it can be pregnancy related, but a disability, for example, gestational diabetes or preeclampsia. It can be a pregnancy related disability, but there must be some condition involved that rises to the level of a disability. This pregnancy and postpartum leave with job protection can be taken for many reasons. Appointments for pregnancy or childbirth, people can get time off for that. Avoiding hazardous work. So think about our hypothetical about, I think, Rosa, who was working in the fields around toxic pesticides. Recovery from childbirth. Typically that's at 6 to 8 weeks, 6 weeks for vaginal delivery, 8 weeks for cesarean section. But could be longer for people who have complications of childbirth, postpartum depression or anxiety, that type of thing. Leave is also available for abortion and pregnancy loss, as well as pregnancy-related conditions like morning sickness, gestational diabetes, depression, and anxiety. Okay, so we just talked about job protection for these issues. Next question is, how can a worker receive income when taking time off for pregnancy, childbirth, and related medical conditions? And the answer is state disability insurance, which provides workers 70 or 90% of regular weekly wages, depending on their income, for up to 52 weeks. So low-wage workers get a full 90%. Others get 70% of regular wages. And a worker is considered disabled under the SDI program and therefore eligible for SDI if their healthcare provider recommends that they don't do their normal work, whether that's because of their physical condition or some sort of complication of their pregnancy or symptom of pregnancy that prevents them from doing their normal work, or because their normal work is hazardous. If their healthcare provider certifies them for one of those reasons, they are eligible for SDI. And it can be taken at any point in pregnancy. And the worker applies for this program with the Employment Development Department, or EDD. Almost all California employees pay into the SDI program. It's completely worker funded through regular paycheck deductions. You can see on this sample paycheck here, we have California State DI under the deductions section. And so you can check the worker's paycheck to ensure that they've paid into the system, but almost all employees in the state of California pay into it with very few exceptions. Like, for example, people who are employed by the University of California, like me, but most properly classified employees, I should say, pay into this system. Okay, let's shift gears now. And we've just talked about what the job protection and income replacement situation is for people due to their pregnancy, their health, their physical needs related to childbirth. Let's shift gears and talk about job protection for baby bonding. So for the birth parent, they're physically recovered from pregnancy, and the purpose of the leave now shifts to bonding with the baby, taking care of the baby. The California Family Rights Act, or CFRA, provides an additional 12 weeks for baby bonding and caregiving during the first year of the child's life, or the first year that the child is in the home for adoptive and foster youth. And I say an additional 12 weeks because that is on top of the time that the person has taken off for their pregnancy or childbirth related medical conditions. So maybe that's 4 months, maybe it's fewer, but this 12 weeks is in addition. Eligible caregivers under CFRA are people who work for an employer that have 5 or more employees. They must have worked for the employer for more than 12 months total over time. And they must have worked for the employer for at least 1,250 hours in the 12-month period prior to the leave. And that's roughly 24 hours per week. So this is to say there's somewhat strict eligibility requirements. It's not as broad as the pregnancy disability leave protections, or the Pregnant Workers Fairness Act protections that provide for leave regardless of how many hours the person has worked or for the duration that the person has worked. But this still covers a lot of people. Important to make sure that families know that non-birth parents are eligible for this baby bonding. The purpose is to bond with and take care of a new child, and so everybody who is a parent of that child is eligible to apply. All right, now again, shifting gears. We're still talking about baby bonding and caretaking for a new child, but we're going to talk about income replacement or paid leave. The paid family leave program provides partial pay, again, 70 or 90%, for 8 weeks of time off of work. Again, almost all California employees are eligible. If you're eligible for SDI, then you're eligible for PFL. Or I should say, if you pay into the SDI fund, then you also pay into the PFL fund. This can be also taken intermittently, although there's some rules around how frequently it can be taken. I think it's 2 weeks, 2-week chunks in California with 2 exceptions. But it can be taken intermittently. You apply with the Employment Development Department, or EDD. Non-birth parents are eligible also for this income replacement. So that means that dads can get, if they're a low-wage worker, 90% of their wages covered for up to 8 weeks to bond and take care of a new child within the first year of the child's life, or the first year that the child is in the home. So that was a lot. It's very complicated. No wonder people need legal aid organizations and WorkLife Law's free legal helpline to help them navigate all of this. I want to share here a chart that we put together that sort of, people can vary from this, but this is a birth parent's typical experience with these programs. So we have time off running along the top, and we have pay running along the bottom. First, looking at the top for time off, job protected disability leave. So when the person is unable to work because of their health and their pregnancy, that's available for 4+ months during pregnancy and childbirth recovery. So it's 4 months under the pregnancy disability leave program, and people can even get more time absent undue hardship for pregnancy, childbirth, and related medical conditions. During that same time, we see along the bottom, for income replacement or pay, the SDI program will give folks up to 52 weeks of income replacement while they're, I put disabled in quotes because you don't actually have to have a disability. You just have to be unable to do your normal work according to your healthcare provider for pregnancy, birth, and related conditions. Once that period of, quote, disability is over, then the baby bonding period starts. And for those who are eligible, baby bonding leave for 12 weeks of job protection or time off is available. Again, people have to meet those eligibility requirements of working 24 hours a week in the last year. And then during that period of 12 weeks off for baby bonding, there is paid family leave or PFL available for 8 weeks of that. And then 4 weeks is unpaid through the state program. Very few employees have access to an employer program. And so that means most people have to go back to work after 8 weeks if they cannot afford to be off. Okay. We're still talking about paid leave, but now want to talk about family caregiving beyond birth. So, paid leave for adults with disabilities or for aging family members. The California Family Rights Act provides up to 12 weeks of job protected leave with continued health insurance benefits when caring for a family member who has a serious medical condition. So, it's the same protection that applies for people who have just had a baby or welcomed a new child into their home. But in this case, it's for caring for a family member with a serious medical condition. And that can include dementia, cancer, diabetes, mental health disorders, or other conditions that sort of require ongoing medical care. So common cough and cold, not covered, but the condition doesn't even have to rise to a level of a disability. It has to be a serious medical condition. And there's, like the regulations have a technical term defining that, but all of these sort of typical conditions that people provide caregiving for would be included. And then the Paid Family and Medical Leave Program, PFL, provides income replacement for up to 8 weeks during that time when the person is caring for their family member. Okay, so who's eligible for this kind of caregiving leave? Employees who are caring for their child, a parent, a grandparent, a grandchild, a sibling, spouse, domestic partner, or designated person who has a serious health condition. Oh, looks like my slides are messed up. Okay, so designated person is somebody, this is meant to capture chosen family. So the standard is a close family-like relationship. Currently, people can designate a care recipient for job protection. In other words, ask their employers for time off. Now that is the law, and they'll be able to apply for paid leave starting in July 2028, and they designate the person at the time of requesting the time off. So this isn't something that they need to decide who it's going to be in advance or something like that. And it's meant to provide the ability to take time off to care for a chosen family. And then for income replacement, keep in mind that the caregiver, the employee, must be acting as the primary caregiver on the days that they file for PFL. Keep that in mind in July 2028, but that's how it works. All right, so what, oh, actually, I'm sorry, I misspoke. For designated person, this would be something to keep in mind in July 2028 because that protection for PFL doesn't go into effect until then. But currently, for income replacement for people who are caring for their family members, parent, grandparent, sibling, spouse, they must be acting as the primary caregiver on the days that they file for PFL. So, what type of care is actually eligible for leave? First of all, a healthcare provider has to certify that the care is medically necessary. So for some folks, particularly those who face language access barriers, income barriers, this is the hurdle, getting the healthcare provider to certify that the care is medically necessary. And I should say that if people are having trouble with their healthcare providers providing medical documentation and certification, that is absolutely something that we help people with on WorkLife Law's free legal helpline. So encourage you to have people call us, or you're welcome to call us to talk about how to intervene with healthcare providers. We do a lot of that, and it can be fairly effective. Oftentimes, medical care providers are nervous about certifying people. They're worried they're going to get sued. Anyway, please let us know if that becomes a barrier for somebody who needs leave, and we can support. So what type of care is eligible for leave? It can include assistance with basic medical, hygienic, nutritional, or safety needs, transportation, physical care, and psychological comfort. So really, it's very broad, and the sort of healthcare provider saying that it's medically necessary is the pain point. So going, for example, with a family member to medical appointments or driving them to appointments, providing psychological comfort and reassurance to a patient who's undergoing treatment, grocery shopping or cooking for a family member who's recovering from surgery, helping a family member eat or bathe, arranging for medical treatment or nursing care, all of these are activities that caregivers might be doing that need time off of work, and they'd be eligible for leave. again, if the healthcare provider certifies. Important note on the rights of undocumented workers and speakers with limited English proficiency. Workers can apply for and receive SDI and PFL, so disability insurance and paid family leave, regardless of their immigration status, so long as they've paid into the system. Everybody who's a W, or almost everybody who's a W-2 employee in California is paying into the system. And that means they're eligible to apply. And EDD has put in place some protections. My colleague Juliana Franco is more involved in this, but has put in place some protections, like this webpage, for example, which would be the best place to start on how undocumented folks can apply for benefits. Also, Juliana, my colleague, has a lot of experience with this. So if this is something that you're bumping up against, please feel free to reach out. And I'm sure Juliana would be happy to talk to you about it. And helpful to know that, I mean, marginally helpful to know that as of the date of this presentation, at least these benefits are not considered public charge for purposes of immigration proceedings. Okay, so when you're talking to people about job protection, there's a few red flags to keep in mind. When we say reinstatement, the person, their job is protected, they have to be returned to their job. They have to be returned to the same or a virtually identical position that has the same pay and benefits. It doesn't mean that they can be returned to any job. Their job specifically may not be available, but the job that they are returned to has to be virtually identical, which means they, can't have now a 2-hour commute where they used to have a 10-minute commute. They can't be paid at a different rate. They can't have fewer hours available, therefore impacting their, overall income negatively. It has to be virtually identical when it comes to the terms and conditions of employment. Also helpful to keep in mind that people can't be discouraged from taking leave. When an employer discourages somebody or interferes with somebody's ability to take leave, that is equally illegal to just denying the leave. So, somebody may go to their boss and say, I need time off, and the boss responds, oh, geez, well, that's going to be really hard. And, you're up for promotion next year or whatever, deters them. That is harder to prove in court, surely, but it is just as illegal as outright denying somebody their right to take leave. And it's often how these things play out. Keep in mind, of course, that people cannot be punished for taking leave, so they cannot be retaliated against for taking leave, including in their performance evaluations, in their performance metrics. So, you were supposed to, serve for the call center person, this many people over the course of the year, and you only served this many people, but like you were off of work for 12 weeks of the year. That all has to be taken into account so that the leave doesn't negatively impact the person. Of course, harassment for taking leave is also illegal. Denial of promotion is something to keep in mind as well. We see that a lot. Okay, so we're going to shift now to our third topic, which is reasonable accommodations. And I'm going to talk first about pregnancy, and then we'll move second to reasonable accommodations for caregiving. So reasonable accommodations for pregnancy, childbirth, lactation, and related needs are changes to when, where, or how the person's job is done to meet their health needs, to reduce pain and discomfort, and or to minimize risk. State and federal law give a right to reasonable accommodations, absent undue hardship, for pregnancy, childbirth, lactation, miscarriage, pregnancy loss, abortion, fertility, IVF, and more sort of related conditions, symptoms, and needs of pregnancy. Under the federal law, the Pregnant Workers Fairness Act, which is at 29 U.S.C. 2000 G. The law applies to employers that have 15 or more employees. And then in California, the Fair Employment and Housing Act, it's at Government Code 12945. That law or those protections apply to employers that have 5 or more employees. This will maybe surprise people. I've been having fun going around to states that have very strong employment protections and letting employment practitioners know that federal law is more protective than state law when it comes to accommodations for pregnancy, childbirth, lactation, and related conditions, including California law. So this Pregnant Workers Fairness Act, the federal law was passed very recently, went into effect in 2023, summer of 2023. There are super worker protective regulations on the books. These regulations were issued under the Biden administration. There are 29 CFR 1636 and Appendix A. If you have a person, a client who needs accommodations for pregnancy, this is where I would start, assuming that their employer has 15 or more employees. It's incredibly worker protective. So, for example, even essential job functions can be temporarily waived under the federal law. Of course, not true under California law. For those who practice regularly in this area or in the disability accommodation area, you know that employers often get out of providing accommodations by claiming that the person would be unable to do the essential functions of their job. Typically not a defense under federal law. There are also strict limits on employer medical certification requests under the federal law, especially in the context of pregnancy, where somebody's needs are constantly changing throughout the different trimesters. Medical certification is a huge barrier to people actually getting the help that they need. In California, there's strict medical certification requirements. Under the federal law, they're very protective of workers, so that it is not as burdensome and so that their privacy is not invaded. We have a lot of resources on our website, pregnantnetwork.org, related to this topic if you're actually helping somebody to get an accommodation. But those regulations I mentioned earlier have a lot of detail about this as well. And as a practical matter, this is a huge relief to folks who don't have ready access to healthcare providers, who are unable to pay them, who have language barriers. It's just a huge benefit of the federal law. And then finally, there are so-called predictable assessments under the federal law that the EEOC has found will, quote, virtually always not impose an undue hardship. So allowing, and by the way, employers aren't allowed to ever ask for medical certification for these things that I'm going to list. And employers are supposed to provide them promptly upon request. So allowing an employee to carry water and drink water as needed, very important during pregnancy, allowing additional restroom breaks, allowing the employee to sit or stand as needed. So, checking customers out at the cash register, I need to sit down. That accommodation needs to be provided like immediately without medical certification, and it will virtually always not impose an undue hardship. Allowing breaks to eat and drink as needed. Here are some examples of reasonable accommodations for pregnancy and why they might arise for those who are perhaps less familiar with this area of the law. Additional breaks to check blood sugar and to eat that could be needed for gestational diabetes. Moving somebody's workstation closer to the bathroom. So I used to be at this cash register. I need to be at this cash register. That could address bladder control issues or nausea. Those come up often in pregnancy. A temporary transfer to an alternate position to avoid exposure to toxins during pregnancy or while nursing. So there are all sorts of toxic exposures in the workplace that could negatively impact a pregnancy, like pesticides, dry cleaning chemicals. So actually having job duties removed or being transferred entirely to a position or role where you don't have to be exposed to those toxins could be a reasonable accommodation. Permission to work from home to avoid viral exposure risk or a painful commute. Excusal from night shifts or mandatory overtime. That could be used to address fatigue or to avoid risk. There's negative health outcomes associated with not sleeping during the nighttime. Time off to attend prenatal appointments. And breaks in private non-bathroom space to pump breast milk or to breastfeed. This is something that is commonly needed by pretty much all lactating workers in order to continue the breastfeeding relationship. When people are away from their babies during the workday, they need to pump milk. And that's because the body is constantly producing milk sort of on the schedule that the infant is nursing. And so if the milk isn't removed, First of all, body receives a signal that the baby doesn't need as much milk and so stops producing as much milk as the baby needs. And also it can lead, if the person doesn't have an opportunity to pump milk, it can lead to health complications. It's painful. There can be infections, leaking, all sorts of problems. And so getting breaks sort of on schedule and regularly to remove the milk using a breast pump, as well as private non-bathroom space to pump milk. There's some degree of disrobing, so most people want privacy, and typically what happens is the milk is then, put in a little baggie or bottle and fed to the infant, so you need a clean space. That is also required not only by as a reasonable accommodation under the laws that we've been discussing, but also break time and space specifically is required under the California Labor Code, as well as another federal law called the Pump Act that was passed at the same time as the Pregnant Workers Fairness Act. I want to share a few practical tips for seeking accommodations. The first is to use our tools on pregnantatwork.org. We have tools for attorneys explaining the law. We have resources for employees, like our Know Your Rights documents, talking to your boss about your bump, talking to your boss about your pump, all about how to request what you need, let your employer know about your pregnancy or lactation. And we also have resources for healthcare providers who are the gatekeepers. Well, we'll get to the healthcare providers in a second. Another practical tip is that unrequested leave is not an appropriate accommodation. And employers should find solutions that allow people to keep working. So often what we see is an employee will come in and say, I need, to sit down during the workday. And the employer will say, nope, we're taking you off the schedule either for the duration of your pregnancy or, forever. That even just for the duration of your pregnancy. That is not an acceptable form of accommodation. Employers must find an accommodation that will allow the employee to keep working. In the event that there truly is no accommodation available, then the employer can put the person on leave. But I think that is a rare case where there truly is no accommodation available. Of course, people can request leave as a reasonable accommodation, but I'm talking more about employers who are forcing people out on leave instead of accommodating them. Also keep in mind that especially under the Pregnant Workers Fairness Act, there's a requirement that the employers engage quickly in providing accommodations. Delay is explicitly prohibited. I mentioned that healthcare providers are the gatekeepers, and we have on our pregnantatwork.org website information for healthcare providers that will hopefully put them at ease in writing these certifications. And we have a one-page medical certification form that can be filled out in like 3 minutes by a healthcare provider. And of course, call WorkLife Law's free helpline for support. I mentioned this earlier, but we are here to help. Okay, last topic, reasonable accommodations for caregiving. And by that, I mean changes to the job that enable or facilitate caregiving. And most commonly in the context of caregiving, that's things like schedule changes or flexibility, shift predictability or stability, so stable or predictable schedules, excusing tardiness, changes in job location like remote work, reduced hours, carrying a cell phone so that loved ones can keep in touch, intermittent time off. All of these accommodations are what caregivers really need. It's hard to get them, but there are some options that exist. First of all, luckily in California, under FEHA, the provision that requires accommodation of disability in employment may also give employees a right to accommodation based on their association with a person who has disability. So this is unsettled, but there's a case, Castro Ramirez, that suggests that this is a possibility. There's some other court cases suggesting this is a possibility. So there is no interpretive guidance from the California Civil Rights Council on this question, but it is possible that somebody may be entitled to an accommodation because they are associated with somebody who has a disability in California. There's also always a comparative right to accommodation, which is to say employers must treat employees who are associated with a person with a disability as well as they would treat others people who are not associated with somebody with a disability when it comes to freedoms or opportunities that might enable caregiving. So if people are excused for showing up late regularly, and then, the caregiver must be excused for showing up. The caregiver who is associated with somebody who has a disability must be excused for the same thing. Otherwise, if they're not excused based on their association with somebody who has a disability, that could be illegal. Another creative solution that we often use for caregiving accommodations is the employee's own health condition. Caregiving employees who are experiencing depression, anxiety, stress disorders, and similar impairments may have legal rights for their own disability under FEHA. And because caregiving can be such a stressful endeavor, often this is the case, especially when it comes to the point where somebody is struggling and needs accommodations at work. Employers have to give accommodations unless it would be an undue hardship when it's for the person's, own health condition. Note, if an employee takes leave or works reduced hours as their accommodation, then pay may be possible under the state disability insurance program that we were talking about earlier. Also, remember to check local laws for rights that may help caregivers. For example, there's fair scheduling laws in Los Angeles, Emeryville, San Francisco, Berkeley, and San Jose. Those typically apply to larger retail and fast food workers, but they're helpful. For caregiving, they require advance notice of schedules and other scheduling protections to promote predictable and stable work schedules. Also in San Francisco, we have the Family Friendly Workplace Ordinance, where employees have a right to request and receive flexible or predictable working arrangements that are needed to assist with caregiving, so long as there's no undue hardship. As I've said throughout, WorkLife Law is here to help. We have free support for caregivers and their helpers, including you all as legal aid attorneys. We have a free legal helpline, 415-703-8276, or email hotline@worklifelaw.org, and our amazing attorneys will get back to you. We also have resources online. The hyperlinks will be in the slides that'll be disseminated, but we have legal rights for caregivers at work, pregnantatwork.org, that covers, or .com, I think both work, that cover legal rights during pregnancy related to reproductive health more broadly, and also the pregnantscholar.com, which provides information for pregnant and parenting students. We also have resources for litigators, for attorneys who are not litigators, who are supporting clients in other ways. We have a free attorney network, and we make, most relevant to this group, we have trainings and resources, some that are behind a protected password protected website that cover legal issues related to the topics we're talking about today. And you are also welcome to call our free legal helpline or to email us at info@worklifelaw.org for support in serving your pregnant and caregiving clients. We are here to help. So I want to go back to these two hypotheticals and talk about how we would apply the laws that we've been talking about today to these people's situations. So Grace works at a call center. Her father, who has dementia, recently got lost after wandering outside when Grace's mother was in the shower. Grace lets her coworkers know that her parents are moving in. And this will allow Grace to support her 72-year-old mother because caring for her dad is an intense around-the-clock job. Grace uses up her state-mandated sick days when her mom gets the flu. The following month, Grace is late on 2 occasions, in both instances because her father was experiencing a dementia-related health issue. Let's assume that she told her boss that. Dad has a medical appointment coming up when big health decisions are going to have to be made, and Grace has to take time off of work early to attend. Her boss responds that Grace can't have any more time off and is going to have to decide whether she wants to take care of her parents or keep her job. So there's so much going on here that implicates like literally every single legal protection we talked about. I mean, the first thing that I would do in this situation is the boss has threatened to retaliate against Grace for taking time off. So I would write a letter letting them know that what they're doing illegal is what they're proposing to do and forcing Grace to sort of choose between her job and caregiving is illegal. retaliation, discrimination under the various laws that we've talked about. But more specifically, I would look into whether Grace is eligible for job protected leave, which can be taken intermittently to do things like attend um, medical appointments. And I would also let Grace know about paid family leave, which could be available on the days when Grace is taking off and losing income to take care of her parents. I'd also talk to Grace about the fact that maybe a reduced schedule could ease some of the burden, and that is a form of job protected leave, and that she could receive income replacement for that as well. Let's pretend that Grace is not eligible. Maybe she didn't work 24 hours and therefore isn't covered by SIFRA. I would start looking at accommodations for Grace. I would maybe help Grace to negotiate with her employer based on her association with somebody who has a disability, and that Castro Ramirez decision that has opened up the possibility that people have to be accommodated for their caregiving of a person with a disability in California. If all else were to fail, I would talk to Grace about her own health conditions and whether the burden, the privilege and the burden, I should say, of caring for two parents has created her own mental health conditions, and whether she might get time off or SDI for that, or accommodations for that. So there are a lot of legal protections that might exist, but you sort of have to know where to look. And again, please feel free to call us. Looking at this last hypothetical in pregnancy, Rosa comes to you for assistance in securing Medi-Cal benefits when she's 12 weeks pregnant. She mentions that it's been a very difficult pregnancy between morning sickness and exhaustion, and that she has to wake up every morning at 3 a.m. for her job picking strawberries in the field. You asked some follow-up questions about work while pregnant. Great job doing that. Connecting the fact that, okay, she's working and this has been really hard. Rosa mentions that she's very worried about the impact on her pregnancy of the pesticides that are sprayed on the crops, as they've made her lightheaded and there are rumors that they are dangerous. When you empathize with Rosa, she responds she has no option but to keep working this job so that she can pay her bills. So I think in this situation, I would talk to Rosa about whether let Rosa know, first of all, that she has rights. And she's come to you for assistance securing Medi-Cal benefits, so you may not be in a position to help her to apply for SDI or to talk to her healthcare provider. And in that case, I would say send her to us at WorkLife Law's free legal helpline, because we can help people in these situations. But if you were in the situation to assist her, I would talk to her about, like, okay, you're early on in your pregnancy, it sounds like, and how would you feel? Would you want to go out on leave for the duration of your pregnancy? Are you receiving prenatal care? Do you think this is something you'd want to talk about with your healthcare provider, or have me write a letter to your healthcare provider about your rights to take time off to protect the health of your pregnancy? That would be a really long time off of your job. How do you feel about the need for job protection? A lot of sort of seasonal workers, the job protection piece isn't as important, it's the pay. And so working with Rosa to apply for SDI, perhaps communicating with her healthcare provider to let the healthcare provider know that this is something that that SDI is available for, could be extremely helpful, especially if there's a language barrier. So I've left no time for questions. Apologies for that. I also can't see anybody because I'm having slide issues, but let's see, how do I pull this back up? If I stop sharing, okay, there we go. I am happy to answer. I've run up against the end of time, so I will let Cassia finish us out. But please do feel free to reach out to me. I'm not seeing any questions. Oh wait, there's one question in the chat. Yes, we assist workers throughout all of California. Actually, throughout the entire country, our helpline is national in scope, although a third of our callers come from California, and a number of us are based here, and so we, interact regularly with EDD and are very well versed in the California issues. Um, yeah, so please, anyone anywhere in the country, feel free to send them to us.